because that could impact on the advice that I provide, what jurisdiction the child will be born in, and do they have or do they intend to instruct a lawyer in their jurisdiction of choice. That's something that I strongly recommend, and I'll cover that in more detail very soon. With regards to the advice that I give intended parents in this situation, I've formulated some key items from my own practice, and which also corresponds with the best practice points set out by Mrs. Justice Tice in the judgment of RZ. There are quite a lot, and they are clearer on the slide, so hopefully they'll be circulated to you after this presentation. But the most important things are to keep a clear chronology of events, urging them to understand the process being promised by international agencies before they sign anything. And by that, I mean how much involvement the agency has with matching them with that surrogate, if they facilitate the communication with them, and what happens when the child arrives. I also advise that they find out how much contact they will have with the surrogate during the process and afterwards, having regard for that requirement that the surrogate needs to provide her consent to the parental order, which cannot be given until 6 weeks after the birth of the child. In my experience, the agencies who usually act as the middle person and essentially block any direct communication with surrogates are those in countries where there's no legal framework. And in that situation, intended parents need to satisfy themselves that the surrogate is not being exploited, which is a factor that the courts will consider very closely. I highlighted on the slide that international arrangements don't override the legislation here, so I still cannot advise on surrogacy agreements in this scenario, but that doesn't preclude the intended parents from obtaining advice from a lawyer in the jurisdiction of their choosing. Again, keeping a record of all payments they've made and to whom, and noting down the reasons for those payments. Usually agencies ask for certain payments to be made at different intervals in the process. That can include the signing on, when there's a confirmed pregnancy, and then later during the stages of pregnancy but before birth. The court assesses those payments in order to determine if they were reasonable in that jurisdiction, and they reference the legal position, the agency agreement, and as Colin mentioned, the living standards of the surrogate, in order to determine if they were reasonable. So anything over and above that will need to have a very good reason for the court to approve them. For example, in the case of RZ that I mentioned, the intended parents were told that there was an ongoing war in the country where the surrogate was residing, and that it wasn't safe for her to give birth there. And the intended parents were then given a choice of 2 alternative countries, but that would cost them an additional €14,000. Another key piece of advice is to keep a copy of the signed agency agreement so that we can exhibit it to their witness statement. I have had occasions where I've been instructed late on, and intended parents have destroyed their copy of the agreement once the child was born. Fortunately, in those cases, it was usually a US agency who were more than happy to provide another copy, but that cannot be guaranteed in every case. Another important thing to note is to keep copies of communication with the surrogate and keep any notes of meetings with her, including times and dates. That's particularly helpful to illustrate the surrogate's position in terms of handing the child over, her consent, and anything that can naturally come out in conversation. Then if for any reason the surrogate cannot be found or able to give her consent to the parental order, that communication can assist the court if a request is made to dispense with it. I always make it clear, as Colin mentioned during his presentation, that a parental order in this jurisdiction is still required, even in circumstances where orders are made in the jurisdiction of choice, where the intended parents have been named as the legal parents of the child. Another important piece to note is that transportation of gametes or embryos to their jurisdiction of choice for implantation, some countries require the sperm or egg to be tested at the time of collection in order for them to be allowed into the country and used. Nancy, I'm on slide 9, if that helps. Thank you. But of course, we have no control over what jurisdiction the intended parents choose, which is why I stress the importance of them doing their own due diligence. So they need to satisfy themselves, because they will have to later satisfy the court that there's no risk of exploitation. They can do this by keep going down. Sorry, I'll get you to the right slide now. Keep going. Thank you. That's it. Yeah. So they need to research the agency's reputation. They can ask other intended parents about their experiences, and get legal advice, which is independent from the agency, is an absolute must. From the beginning, the intended parents need to ensure that surrogacy in their jurisdiction of choice is legal for them. So in the case of REZ that I referenced earlier, the intended parents were in a same-sex relationship. The agency they chose recommended that only one of them signed the documents as a single male, so that they didn't run into any problems. That should have been a very big red flag for the intended parents, but their position was they had received no legal advice at that stage. So if you go on to the next slide, please. So in terms of due diligence with regards to the surrogate, the intended parents can ask her some information, including about contact. Will this be direct and consistent with her? Does she understand and know what her legal status will be to the child at birth, and what the implications are of any orders altering this? Does she speak English? And if not, will the surrogacy agreement be translated to ensure that she understands and knows what the terms are? What information has she been given about the process and the intended parents themselves? In the case of REZ that I mentioned, it was only during the pregnancy that the surrogate became aware of the intended parents being in a same-sex relationship, and the court, understandably, raised a concern as to whether her consent to a parental order was given with her full understanding and knowledge of the relationship, or on the misleading information that she was given by the agency. Fortunately, in that case, the intended parents had obtained all copies of communication with her to show that she was made aware, was happy to proceed, and she had in fact offered to be a surrogate again for them in the future. It's also good to know what support she will have, both from her own support network and what she expects from the intended parents. Is she sufficiently prepared for the role that she is undertaking? What legal advice she will have in terms of the local law and the legal process here, so making sure she understands that she's required to give her consent and how that is given to the family courts in the UK. And location, to ascertain if she has any other ties with any jurisdictions, so including where she intends to reside during pregnancy and for the birth, so that the intended parents can determine if they need to obtain any advice in any of the jurisdictions. So I'm now going to consider why it is best practice to obtain local legal advice. And this was noted in the case of CC and DD, which is a 2014 recorded case in the UK, that highlights the legal complexities in this area of law and the need for those who embark on international surrogacy arrangements to ensure they have expert advice, both here in the UK and in the jurisdiction where the arrangement is taking place. So it's best practice to know the legal position of choice in the jurisdiction of choice as early as possible, so that we can frame the case and all of the supporting evidence accordingly to illustrate to the court that the intended parents have complied with those legal requirements. As I mentioned, this will be scrutinised closely, and I strongly recommend that the lawyer providing this advice is independent.
Oh, about surrogate is the lecture. I will go out.
Sarah, sorry, kindly unmute yourself, please.
Please, everyone, let's mute our mics, please. Please, only the speaker's mic should be unmuted. Tara Smith, please, can you unmute your mic so we can hear you? Sorry for that disruption.
Yeah.
Thank
Can
you.
Can you hear me now?
Yes, please, we can. Thank you.
Great. So ideally, the advice that the local lawyer will provide will be in writing so that we can attach it to witness statements, but also include a breakdown of the law in that country and how it applies to the intended parents, an explanation about the surrogate status at birth, the intended parent status at birth, and if there's any positive steps that they need to take in order to be recognised as the child's legal parents, and who will be named on the birth certificate, for example. Another very important factor to consider is immigration advice, as Colin touched upon, to ensure that any resulting child can be brought back to the UK and what their status is once they arrive here. As you can see from the slide in front of you, this should confirm what steps will be required and how long it will take to obtain the relevant paperwork for that to happen. I've had cases where intended parents have travelled to the relevant country for the birth of the child, who essentially then become stuck waiting for travel documents because they hadn't prepared anything in advance. So my approach really in international surrogacy cases is to coordinate all the legal advice from all relevant jurisdictions early on, so that intended parents have a clear action plan before they enter this process, because any small variation can impact the outcome for the intended parents, and more importantly, any resulting child. So the next slide is the final slide from me, and it's just some final points. For example, in international cases, the surrogate's consent, which is provided on a generic form, it needs to be signed in the presence of a notary, a practical arrangement that should be made aware to the surrogate so that early on inquiries can be made and notary instructed and ready to go when required. The last few points are just a reiteration of the best practice that I undertake on these cases about keeping in regular contact and preparing as much as possible. But overall, international surrogacy is becoming increasingly common. As Colin mentioned, it constitutes nearly half of applications for parental orders here in the UK, purely because it offers a speedier way for intended parents to be matched with a surrogate. But it is more complex, which is why applications in this scenario are dealt with by the High Court at the Central Family Court in London. So it's really important that we as lawyers can offer those intended parents well-rounded advice so that they enter into this process with their eyes firmly wide open. That's everything from me. If you have any questions, I will stick around, but the slides also contain my contact details. So thank you all for listening.
Thank you so much, Tara Smith, for that succinct presentation. We're very grateful. Thank you so much. From your presentation, what I could pick from the relevant information is that regardless of the desire or need of intending parents to go into surrogacy agreements, they must ensure they have legal documentations. They must ensure their papers are right. They have proper documentations of the transactions that take place, the agreements, the communications, and all that, so as not to jeopardize all that they've done. So thank you so much for that insight. I'm very grateful. Okay, we ought to have our next speaker before the question and answer. If Nba-Slp is ready, would love to take his paper. Ready for us?
Yes, we're ready. Good afternoon.
Okay, so just before you,
Okay.
sorry, just a minute, before you go on, let me read the profile of Lene. Okay, I've already done that, so please continue from there. Thank you so much.
Okay, so I am Lillian Eku, an associate in Omaplex Law Firm, and I'll be representing the Leonard Silk, who is unavoidably absent. He traveled, so he will not be able to join the program today. But I'll be presenting his paper. So it's all comprehensive, though it's very lengthy. So I beg everyone
Sorry, but I would please plead that you speak to the paper. You have 25 minutes for that. Thank you so much.
Okay, all right. So the introduction on the paper. So I would like if you could share this the slides. Okay, so the analysis of the Nigeria Surrogacy Regulatory Commission Bill. So please go to the next page. Thank you. Okay, so I'll just briefly say what's here. Over the years, different countries in the world have had diverse views and approaches on the concept of surrogacy. Surrogacy is a concept that is yet to be widely recognized and accepted in Nigeria because of the diversity in beliefs and norms, which are influenced by factors like religion and culture. As a form of assisted reproductive technology, it is generally considered to be a treatment for infertility, wherein a woman known as a surrogate mother becomes pregnant on behalf of another woman, referred to as the commissioning mother, and subsequently delivers the baby for her. Thus, surrogacy constitutes an arrangement wherein a woman acting as a third party bears a pregnancy on behalf of the intended parents and relinquishes the child to them upon delivery. Notably, the practice of surrogacy has garnered considerable attention, prompting initiatives to establish international frameworks aimed at ensuring best practices in the field. So the next slide, please. The House of Representatives recently passed a bill seeking to establish the Nigeria Surrogacy Regulatory Commission for monitoring and supervision of surrogacy arrangements in Nigeria. The bill aims to provide for the registration, regulation, and monitoring of surrogacy agencies in Nigeria and related matters. In 2012, a similar bill, which is the bill for the establishment of a Nigerian Assisted Reproduction Authority, was presented before the National Assembly and was read the second time on 2nd May 2012. However, it was not passed into law as it did not enjoy the support of the majority of the National Assembly. Finally, it is imperative to undertake a critical analysis of the Nba-Slp bill, that's the Nigerian Surrogacy Commission Bill, vis-a-vis the United Kingdom surrogacy laws, putting into consideration international best practices on surrogacy. This is the next slide. So we have the establishment of the Nigeria Surrogacy Regulatory Commission Bill. The Surrogacy Bill 2024 basically seeks to establish the NSRC for the monitoring and supervision of surrogacy arrangements in Nigeria, and to provide for the registration, regulation, and monitoring of surrogacy agents in Nigeria. This is loosely spelled out in the long title of the bill. The bill introduces the NSRC, which shall be a body corporate with perpetual succession. The body will be responsible for the following functions, which is establishing and maintaining a surrogate registry in the Federal Capital Territory and in each state of the Federation, regulating and overseeing all matters relating to surrogacy in Nigeria, and advising the minister on policies and regulations governing surrogacy. The next slide. The next slide, please. The surrogacy bill. Okay. The surrogacy bill seeks to prohibit commercial surrogacy in Nigeria. Thus, no person or entity is expected to offer or receive any payment, benefit, or consideration whatsoever in exchange for arranging a surrogacy. Acting as a surrogate or entering into a surrogate arrangement, failure to adhere to this provision carries with it a sanction to be prescribed by the Act. Thus, going contrary to the provision amounts to illegality. However, this may present a challenge as some women may be reluctant to act as surrogates due to the anticipated expenses they may incur in the course of being involved in the surrogacy. Eligibility for surrogacy in Nigeria. The bill is to the effect that only persons eligible for surrogacy in Nigeria are persons who have been medically certified as unable to conceive or carry a child to term, whether they are married couples or single persons. So, persons other than those medically certified as unable to conceive or carry a child to term are ineligible for surrogacy in Nigeria. The next slide, please. So we have the minimum age requirement. The minimum age for a person to act as both a gestational or genetic surrogate is 21 years. Notably, gestational surrogacy involves the surrogate becoming pregnant through a process called in vitro fertilization. In this process, an embryo, that's IVF, popularly known as IVF. In this process, an embryo is created in the laboratory and transferred to the surrogate's uterus. Consequently, she will not be genetically related to the child. On the other hand, genetic surrogacy, also referred to as traditional surrogacy, involves the surrogate mother providing her own egg, which is then fertilized with the intended father's sperm or donor sperm by artificial insemination. The surrogate then carries the fetus and gives birth to a child on behalf of the intended parent.
Yeah.
Importantly, the bill proposes a penalty of 500,000 naira or imprisonment for a term not exceeding 3 years or both for any person who contravenes these provisions. Next slide. Consent of parties. The bill is also to the effect that a surrogate agreement must be made voluntarily and based on the informed consent of all the parties. It must also be made in writing and signed by all parties involved. Additionally, it must be registered with the NSRC before the commencement of the surrogate arrangement. It appears that this provision is relevant as it will enable the NSRC to ensure that the agreement is in compliance with the law. Medical evaluation. The bill makes a vital provision to the effect that before any surrogate and the intended parents enter into a surrogate arrangement, they must undergo a medical and psychological evaluation to assess their physical and mental suitability for the surrogacy process. The essence of this provision is to ensure that both the surrogate and the intended parents are medically and psychologically fit to participate in the surrogacy process. By mandating these evaluations, the provision seeks to safeguard the welfare of all parties involved, as well as to prevent potential physical or mental health complications that may subsequently arise. Notarization. The bill makes it mandatory for every surrogacy arrangement entered into in Nigeria to be notarized by a notary public or executed before a commissioner for oath. The bill intends to serve as evidence that parties consent to the arrangement and that they understand its terms and conditions. The next slide. Okay. Surrogacy Arrangement Act 1985. There's some United Kingdom laws on surrogacy. So I'll just briefly touch on some international laws as it's written in the paper. The Surrogacy Arrangement Act 1985 is a piece of legislation in the United Kingdom that regulates surrogacy agreements. The law, which has been in existence for over 30 years, contains some salient points that shall be examined briefly below. The SAA, that is Surrogacy Arrangement Act 1985, is popularly known for its provision for the unenforceability of surrogacy arrangements. The Act provides that no surrogacy arrangement is enforceable by or against any person of the persons making it. Thus, even where both parties agree to certain terms, these terms cannot be legally compelled or enforced by the courts. The Act prohibits any commercial arrangements related to surrogacy. In essence, no person shall make any negotiation on a commercial basis with a view to entering into commercial agreement. In other words, the person who contributes to the making of a surrogacy arrangement and receive payment or act with the intent of receiving payment will be committing a criminal offense. However, where a surrogate mother herself or a person with a view to a surrogate mother carrying a child for him or her does any act in the aforementioned section 2, subsection 1 of the SAA 1985, it shall not be an offense for such a person. This entails that third parties are prevented from profiting from surrogacy arrangements. Please, next slide. The SAA 1985 prohibits any form of advertisement that suggests that a person is or may be willing to arrange or facilitate a surrogacy arrangement, or that a person is searching for a surrogate mother or seeking individuals who want a surrogate. However, this prohibition does not apply to advertisement by non-profit organizations, provided the advertisement only involves actions that wouldn't violate section 2, subsection 1, even if done commercially. Finally, the Act provides that a person who contravenes this provision is guilty of an offense. The next slide. The Human Fertilization and Embryology Act 2008. The Human Fertilization and Embryology Act 2008 seeks to ensure that the regulation of assisted reproduction and embryo search is fully up to date with scientific advancement and evolving societal values. It amended the Human Fertilization and Embryology Act 1990 and maintains the Human Fertilization and Embryology Authority as a body responsible for implementing the Act. The Act outlines the eligibility criteria and process for obtaining a parental order, which legally transfers parental rights from a surrogate, for instance, to the intended parents. These sections balance the rights of the surrogate, who must consent to the order, and the intended parent, who wish to establish a legal relationship with the child. Next slide. The proposed bill on surrogacy in Nigeria has some similarities with the laws governing surrogacy in UK, although differences abound. Firstly, both the Nigerian bill and UK surrogacy laws prohibit commercial surrogacy. However, while the Nigerian bill appears to prohibit every person involved in a surrogacy arrangement entirely without any exception, this SAA 1985, that's the UK law, provide that it shall not be an offense for a surrogate mother or intended parent to engage in commercial surrogacy. Thus, it appears to only prohibit third parties from benefiting from the surrogacy agreement. It is an offense for them to do so. Furthermore, while the SAA 1985 expressly provides that any surrogacy arrangement entered into the UK is unenforceable, there is no such provision in the Nba-Slp Bill 2024, that's the Nigerian bill. The bill rather made provisions that will ensure that a surrogacy arrangement must be in writing and with the informed consent of all parties involved, which must be registered by the NSRC, prima facie, that's physically. It seems that the bill intends for the arrangements to be enforceable, with surrogacy being regarded as a contractual agreement. Additionally, pursuant to HFEA 2008, a parental order must be obtained from the court by intending parents so as to transfer parental rights to the applicants. This provision is not embedded in the NSRC Bill 2024. Consequently, this omission in the bill may translate to mean that there is no requirement for such parental order in the Nigerian jurisdiction once the provision of the law, especially with respect to the surrogacy arrangement, is compiled with by all parties involved. At this juncture, it will be pertinent to consider some international best practices on surrogacy. This is relevant in understanding how countries are expected to approach the regulation, ethics, and legalities surrounding surrogacy arrangements. It is important to state that the various countries in the world should have a comprehensive framework on surrogacy, clearly defining the legal rights of the different parties involved in surrogacy. Thus, it is a laudable development in Nigeria to see that the National Assembly is in the process of enacting a comprehensive legislation on surrogacy so as to clearly define the rights of the parties involved. A major key principle of international best practice in surrogacy is ensuring that the best interest of the child is upheld. The best interest of the child must be the paramount consideration in decision-making regarding children born through surrogacy. Next slide. All parties involved in surrogacy should receive in-depth counseling to ensure they are comfortable with their decision. Children born through surrogacy should not be discriminated against, but accorded same rights as other children born through the usual procedure of childbirth. Legal parentage is also relevant. It's also another relevant issue to be considered. It is important for legal parentage to be established to determine the legal parents of the child. For instance, the UK law provides for a court order to vest legal parentage in unintended parents. This is not a requirement in the proposed law on surrogacy in Nigeria. Okay, the NSRC Bill 2024 introduces the much needed legal framework for surrogacy in Nigeria, aiming to safeguard the rights of all parties involved. It is a welcome development in Nigeria with respect to the practice of family law for an extended period. There have been recommendations by professionals on the need to have comprehensive legislation on surrogacy to address certain legal, ethical, and medical issues surrounding surrogacy in Nigeria. It is my recommendation that the bill should integrate more international best practices in order to ensure that the welfare of all parties is protected. Okay. So that's all for the paper.
Thank you so much, Leonard Sick, ably represented by Lillian. We're very grateful. Thank you for speaking to the paper and for maximizing your time. This you've given us extra 5 minutes to work with. We're very good. Thank you. And from the presentation we've seen by Leonard Sick, it's analysis of the surrogacy bill being introduced into Nigeria. And the recommendation is that the bill should integrate more international best practices to safeguard the interests of all the parties involved, both the surrogates, the intending parents, and the unborn child. So thank you so much again, once again, for that paper. Thank you. Okay, so moving on, we can see that we have so many comments and questions on the chat box. And
sorry, Mr. Moderator,
okay, thank you.
An intervention. At the beginning of this webinar, after the delivery of the keynote address of the forum, the honorable member said that his wife was here with us, and I was wondering if this would be a good time to have her make an intervention because it's good to hear also from people who have had this surrogacy arrangement. It's usually a very sensitive topic, and if somebody is happy to share her experience, I think we would welcome that. So if Mrs. Aloa Kala is still here, we would yield the floor to her for 5 minutes. Thank you.
Sorry, excuse me. May I quickly ask if the materials would be emailed to us, like the paper that was just spoken to now, and maybe other speakers? Is it possible to have this material so we can
So
take out?
Patricia, we're happy to have a very interactive webinar. The chat box is there for us to ask our questions and
Okay.
be attended to. If everyone had to say something, I'm sure we would not finish today. So that will be addressed in the chat box. But yes, of course, if I'll just say it straight, the participants will be able to have the papers delivered. So we yield the floor now to Mrs. Aloa Akala, and Chris Daniel, you can continue with the moderation. Thank you.
Yes, please. Is Ms. Alao present, please? Okay, in our absence, will we proceed to question and answer?
Present, I'm here.
Can see
I'm here. Can you hear me?
Ms. Alao, she's here, please. Ma'am, you're welcome. Over to you, ma'am,
Yeah.
please.
Thank you so much. Okay, thank you so much. Thanks for having me here. Yeah, my husband is the keynote speaker. He's the first person that spoke, Honorable Olamide Alawa Kala, who is a representative of the House of Representative member for the 10th Assembly in Nigeria. So he has a bill, the surrogacy bill, which is the first of its kind. So and as he mentioned, you know, this is a bill that's very close to us as a family. We welcomed twins 2 years ago via surrogacy. So again, my name is, for those that don't know, Hadiza Riza Alawa Kala. And I'm excited to share some insights on a topic that's both personal to me and deeply significant to me and my family. I'm British. I'm a British citizen who successfully had twins through surrogate in Nigeria. And my experience navigating the regulations, both in Nigeria and in the UK, has shown me the need for clearer and more consistent guidelines. Today, I'll be discussing the Nigerian Surrogacy Regulatory Commissioning Bill, comparing it with the UK surrogacy law and exploring international best practices to address the challenges we're facing. This bill is crucial to step towards, sorry, I can hear myself. This bill is a crucial step towards regulating surrogacy in Nigeria, providing a framework for the rights and responsibilities of intended parents, surrogates, and the children involved. Currently in Nigeria, surrogacy landscape is fragmented with a lack of clear guidelines and legal protections. This leaves all parties vulnerable to legal uncertainties. A well-defined regulatory framework is essential for ensuring that everyone involved is treated fairly and with dignity. So if you compare it to the UK surrogacy law, which I had to pass through, the process is more structured. So even at the beginning, you kind of know what you need. So, you know, I knew that my surrogate needed to be, well, it was best if she wasn't married so that the complications wouldn't be as much, you know, when passing to the UK legal law, because obviously I wanted my kids to be UK citizens after, you know, their birth. But, you know, if your surrogate, you know, depending on if your surrogate is married or single, it will also mean the kind of process that you need to go through in order to gain citizenship. citizenship for your baby once, you know, they're born. And you also have to be aware of the legal implications that come with having a child outside of the UK if you're British, etc., etc. So in Nigeria, these are things that we don't really put emphasis on. These are things that we're not sure about, or we don't, obviously, you know, there's, if you need any legal sort of guidance, you can't get any. So, you know, I'm really happy that the bill is going forward for something like this, so that, again, someone like myself going into surrogate, or a surrogate that wants to be a surrogate, you know, someone that wants to be a surrogate actually can have guidelines and know the diligent process to take, so that they're protected, not just for now, but for legal reasons. And also we need to take away the stigma, you know, this will help take away the stigma and the taboo of surrogacy in our country, because, you know, there's a lot of, you know, most people, most times here in Nigeria, those that want to be surrogates tend to be more vulnerable people that don't actually have the education and the background knowledge to understand the implication of what this means and what this entails. Also, if the person that, you know, someone like myself that wanted to, that needed a surrogate, if you're not aware of the legal implications, you know, I was actually advised when I did surrogacy to kind of overstep the part where you tell people that you did surrogacy and say that, you know, I just kind of did it myself and go ahead. But of course that would bring legal problems, or could bring legal problems in the future. For example, if the surrogate then decided that she wanted, you know, to you know, kind of have the children back, you know, for whatever reason, she could then contact the UK legal system, and, you know, through law, kind of, you know, if she doesn't sign any affidavits or anything, can actually have the rights to my children in the future. And of course, that can cause legal implications abroad. So here in Nigeria, I'm very happy that we're putting this together, and you know, we are gathering and making this legal, basically, and putting guidelines so that, you know, all these sort of issues that I've mentioned don't happen to people that are working naively or ignorantly or not sure of the information that's out there, or for those that, of course, that are vulnerable in situations like this. So obviously I would suggest and say that we can learn from international best practices from countries like the US, Canada, and UK. You know, I know we might not be able to follow the rules exactly because, you know, there are society issues and also religious implications that we need to consider. You know, so, you know, in Nigeria, kind of, if you ask a surrogate to be a surrogate without payment and stuff, you probably won't get enough people wanting to do this. Most people do it for reasons, or monetary reasons. But again, if they can at least know and have some sort of guidelines to protect them both now and in the future, once it's all said and done, that would be good. So I'm not sure if you guys can really hear me, so I will stop there. I won't go on. I know my internet connection's a bit shaky, but I would just end and say, I strongly urge that we have a public enlightenment on surrogacy in Nigeria, just to take away the stigma and the taboo of it all, and to raise awareness despite, you know, myths and everything, and push the legal framework so that at least the future of surrogacy can be good for all. Thank you so much.
Thank you very much, Mrs. Adizot Akala, for sharing your experience with us. We're very grateful, and thank you for your candid opinions and advice. Thank you so much for that. Okay, moving on, it's question and answer time, and we have some questions already in our chat box. So due to our time, we'll be taking just a few of them, and we believe you'll get the answers you're asking for. So question 1, I'll take from someone asked. This question is directed to Collins Rogerson. If you're still here, please. Said, can you please throw more light on the enforceability of surrogacy arrangements in the UK? Question is by Okuchi Chima Agbara. Please, Mr. Collins Rogerson, can you please throw more light on the ability of surrogacy agreements in the United Kingdom?
I don't know if Colin's here, but I could answer that on his behalf, and that it's a very quick
Thank you so
answer.
much.
It's a very quick answer. They're not enforceable in the UK, and it is a criminal offence for us as lawyers to advise intended parents and/or surrogates about the contents of surrogacy agreements.
Oh, thank you so much. Okay, the next question. It's, would there still be need to identify the identity of a surrogate under anonymous surrogacy agency? Would there still be need to identify surrogates under anonymous surrogacy agency if an IP wants to take their child to UK? That question is by Unwadiotu Machuku.
I'm not sure I completely understood the question, but if there's any donor material being used in the UK, then as long as it's done at a licensed fertility clinic, and when they provide the donations, then the donor signs away any legal rights to any resulting child. So there's no issues about that third party involvement within this process. And we have limits for how much or how many families can use those donations, and it's a maximum of 10 in the UK. And I'm sure you would have all seen the news where these big tech CEOs are offering their sperm to multiple women across multiple different countries, so that their biological material can be used to create children. That wouldn't be the case here in the UK.
Okay, thank you very much. Okay, another question is, please, if a child is born in Nigeria through surrogacy processes and the intended parents are living in the UK, what is the necessary documents to prepare for the intended parents to carry the child along to UK? By Blessing Ozioko.
I'm not an immigration lawyer, so I wouldn't know exactly what the travel documentation is, but that's the scenario where I'd recommend they speak to a Nigerian immigration lawyer to understand what travel documents the child needs in order to leave the country and come to the UK. And they would also need the advice from an immigration lawyer here in the UK to ascertain what that child's status is once they've arrived here, and what the intended parents need to do to get citizenship for the child if that is available in that scenario. But yeah, that's definitely the scenario where immigration advice would be needed in both jurisdictions.
Okay, thank you so much. So to the person that asked the question, it's simple that for you to know the relevant documents for Nigeria, you need to get an immigration lawyer to advise you properly on that. We're very grateful, Tara Smith. Okay, so we have some comments here in respect of the reason why the applications for the parent of child for a child born through surrogacy, it's because it is sensitive to change the child's parenthood, so through private agreement. Therefore, it's court that should establish the parenthood, so there won't be exploitation or abuse of any party. Okay, thank you so much, Ayo Tundu Ogun Jare. Okay, the next question. Just a minute, please. So someone
I
was
will
asking
step in and help her.
Okay, please do.
No, I thought you were struggling with the next question. I can see one
Yes,
here.
I was trying to
The
get
second speaker, I got been answered
okay.
that there is no legal protection for a UK citizen as a party. Did he say that the surrogacy agreements are not enforceable by either party in the UK? So that means there is no legal protection for a UK citizen as a party. Does that make any sense? Tara, is that something you can speak to?
Yeah, it's a bit complicated and goes into various different avenues, but because the surrogacy arrangement isn't enforceable in the UK, that's why the intended parents have to go through this parental order process here. If for any reason they're precluded from doing that, then there's other options such as asking the court to make a child arrangements order for the child to live with the intended parents, which then gives them parental responsibility, and which is a really big, important factor here in the UK. And parental responsibility will enable the intended parents to make decisions for the child, including medical decisions, where they live, what religion they'll follow, that kind of thing. So yes, there's no protection, but there are other methods that the intended parents can take through applications to the court to secure that child living with them. And don't forget as well that the court's overriding objective is to meet the best interests of the child, and they will always find a way to make sure that that's upheld in their interests. So yes, although they're not strictly enforceable, there's other applications that can be made here to protect the child.
All right, thank you. Chris, please carry on.
Okay, thank you so much. So if from what you're saying is that for there's a bit of protection, though it's technical, the parents still have the right to get full custody of the child that was on through surrogacy by court order.
Yeah, so the parental order basically will strip the surrogate and her husband, if applicable, of their legal parent status and replace them with the intended parents, so that on the child's birth certificate, it will be reissued in the name of the intended parents, being that child's legal parents. If for any reason they can't undertake that parental order process, then they can make an application for an adoption of the child, which will give them that legal status as the parents, but not that biological acknowledgement. So if one of the intended parents is biologically related to the child, or both of them are, then that birth certificate and their biological status won't change, if that makes sense. And also that child arrangements option won't affect the biological status of the child, but it will affect the legal status. So there's two avenues to think about. So ideally, if you're going through the surrogacy process, you want to know that you are going to be legally and biologically acknowledged as the child's parents. But of course, if that doesn't happen, there are other avenues, and the court will be willing to look at those other avenues as well. For example, there was a case recently where a parental order wasn't an option initially because the surrogate didn't consent, and then the adult child actually wanted to bring a case for that to be revoked and for the intended parents to actually be named and acknowledged as the biological parents. So it can be messy, it can be very convoluted, but there's ways and means of doing it in imaginary ways as well. that we can think up of to work with the families and the court to identify what's in the child's best interests. I hope that answered the question, Christopher.
Yeah, thank you so much, Sarah. Okay, one more question from Sarah Ajil Jola. We're talking about the surrogate being the legal parent of the child until a court achieves the surrogate of that. What happens in the situation where the surrogates, the eggs and sperms of donors were used instead of that of the surrogate? Will the surrogate still be the legal mother of that child?
Yes, they would, because under UK law, the woman that gives birth to the child is automatically recognised as the child's legal parent. So even if her genetic material isn't used in the creation of that embryo and the child, yes, they would be recognised as the child's legal mother under the law here.
Okay, so thank you. So it's beyond just having the sperm and the egg. It's who carried the baby and who gave birth to the child that is termed the legal parent of that child. Okay,
Exactly.
thank you so much. We're very grateful. Okay, we'll go to Honorable Olamijuwonla Alawo Akala. Are you still here, sir? Because someone asked an important question. It's like if I made a comment that if you ban commercial surrogacy in Nigeria, you end the chances of many women from having children. Laws should be made in accordance with the environment, not borrowed laws, by Chichi. So that's our own view in respect of the proposed bill for surrogacy. So it should be made to. So, Honorable sir, are you there?
Yes, I am. I'm here.
Okay, sir.
Please come up with the question again, please.
Okay, someone said if you ban commercial surrogacy in Nigeria, you end the chances of many women from having children. Laws should be made in accordance with our environment, not borrowed laws.
Oh yeah, exactly. We can't ban it now here in Nigeria because banning it's not even part of my bill doesn't say about banning it or talking about the commercial. Just talk about regulating it. If they ban it, I will have my own kids also. So it's not about banning it. It's more of like regulating it and ensuring that, like when the Speaker of the UK was talking about their own, they also want to repeal some of their own laws also to enable them the opportunity to be able to have it done on the ground, have it done in England. Most of the surrogates they use when you're in UK now, you have to go abroad to get surrogates. But that's not the case. What we want to do in Nigeria, you want to make sure it can be commercial but not exploited. You understand? It can be commercialized but not abused. You understand? That's what we're aiming at. To make sure that it is well commercialized and well managed and well. It's put. I don't want to use the word commercialized in that aspect too much because if you commercialize something, you're making it like too transactional, or you want to make it out because it is a sensitive issue. Having this surrogacy is a very sensitive issue to many of us. Yeah, like I said, this bill to me is not just a bill because just add to my laurels at National Assembly. It's something personal to me. It's a journey I went through. With my wife. So we're not trying to remove it totally. We just want to find a way that we can reduce and make sure that all parties involved are protected and that all are welcome. Because very soon we'll be having the public hearing, and in the public hearing we'll be able to all streamline the bill properly to the way we want it to be before it comes out and become a law very, very soon. And everybody is welcome. And I'm sure I'm going to pass the time for the public hearing. I'm going to the dates through this platform also, so that everybody can be fully informed and that contributes on iota. Thank you.
Okay, thank you so much, Honorable. So for Chichi and everyone asking, there is no total ban of commercial surrogacy in Nigeria, just that it's meant not to exploit people unduly. So if you want to accept to be a surrogate, it should not be a full financial venture. It should be something you're willing to do to assist someone that is in need, but you'll be paid adequately to cater for your needs and for the expenses related to such transaction. Okay, thank you so much. So someone asked, please, if preparing agreement, should it be intended parents, surrogates, and agency, or who are the parties? A blessing, Ozio Kurada.
Okay, I think
answer.
this is one of the reasons why we are having this conversation here today. What you just asked now, it's a bill that we have, not a law. So we are hoping that we would shape the direction in which the eventual law, the acts of the National Assembly would take. So we can't have an answer, I think, based on what we have already as a bill. I think it's an issue that should be taken into consideration. Because if you ask that question now, for example, Atoyebi, let's say, who tried to analyze the bill, is not here to profile his thoughts in that regard. But we welcome all suggestions that would see to a good law, because what is worse than not having a law is to have a bad one. And that's why we're here today, to have this conversation, see what gap we have in other legislations in other jurisdictions, and make sure that ours is a lot better to serve the interest of Nigerians, to be tailored towards our beliefs, our culture as a people. So I think you can also go ahead, Chris, and read out some of the things that people have been saying in the chat group. Honorable, did you want to say something to that?
I can upload the bill if you want me to. I can upload it to this webinar.
Fantastic. That's very much welcome. Yes, please.
Okay, I'll upload it now so that people can go to it. I'll upload it now.
Thank you.
You're welcome.
And if I would also add, please, members of the NBA, there is the CLE point that we all want to enjoy at this time. So go to the chat and click the link so that you can get your certificates for participation. Thank you. Chris, carry on. There are interventions by people, and if anybody feels very strongly, I think we still have some few minutes. Oh no, we are running out of time, but if there is a strong intervention from anybody in the audience, we would welcome it. But there are various comments in the chat box that are really crucial that we can share and progress our conversation.
If I may, good afternoon. If I'm permitted to
on at this time.
Okay, sorry, please.
Good afternoon.
Please do moderate. Carry on.
Hand is up.
Yes. Good afternoon, everyone.
Can you hear me?
Yes, we can hear you, Madam Udunga. We can hear you.
Good afternoon, everyone. Permit me to stand on existing protocol. Thank you to all the speakers and the NBA-S section for this insightful session. I'm very excited because I'm one of the few Nigerians who practice fertility law, who are qualified in Nigeria and in the UK. And so this is right up my street. I would like to say that this bill is a good start. It's a start in the right direction, but there are very many issues that are still missing. If you compare it with the Human Fertilization and Embryology Act of the UK, you'll find out that there are a lot of gaps. One of those, which is of very importance to a lot of my clients, is the question of parental rights in surrogacy and donor conception. This is not yet included in the bill. We need some clarification about who becomes a legal parent of a child in the event of a surrogacy and a donor conception. there are a lot of issues about data protection and privacy. These things have not been very, they're not been very carefully articulated. I give you a typical example. The Honorable has just talked about Section 9, where it clearly makes a blanket prohibition on commercial surrogacy in Nigeria. It needs to be a little bit more nuanced if he's saying that we are actually allowing altruistic surrogacy to obtain. So it can't be a blanket prohibition on no recovery, no payment, no consideration at all. So these are quite a few of the details. And then another thing which we also need to consider is this, what we're asking, what we're trying to do is legal reform of the biggest kind, of the most extensive kind. This bill, if this bill is eventually passed, it will require the reform, the amendment and the repeal of many existing laws. I give you a typical example. We have the issue of posthumous conception. The Evidence Act says that a child born to a widow within 10 months of her husband's death is automatically presumed to be the child of the dead man. But because of technology, that 10-month limit is artificial. A child can be born outside the 10 months, and the child can be born to somebody who is not even the widow, can be born to a surrogate. So technically, such a child born in Nigeria right now will be in legal limbo. We had a case recently where we actually had to appeal to the court to ask for an exhumation because none of the relatives of the dead man were willing to provide a DNA test. So I commend the Akalas for a bold move in the right direction. We have two other bills which didn't see the light of day by Senator Honorable Tedros Show and also Honorable Barrow, which also reached the same stage, the second hearing and went to the report stage, and they died. And that is one of the reasons why people who are interested in legislative making say that the report stage is really, the committee stage is often called the graveyard of bills. So I commend this seminar, the NBA, but I think there's a lot of work that needs to be done for us to come up with a bill that is in keeping with our specific cultural and religious context. But I must commend the Alao Akalas for being so open about their journey because there are very few people in their situation in Nigeria who have been willing to share their experience. And for that, they have my heartfelt thanks. Thank you.
Thank you so much, Odinga. Okay, Ebele Chuku, I can see your hands up. Please, can you make an intervention?
Hello, good afternoon, everyone. I also want to stand on the existing protocol. I already pointed out something on the chat room, but I just felt I should further buttress it. And that's the point that UK, I'm happy they gave us their own idea of their surrogacy bill. I also want us to acknowledge the fact that they are also looking at tweaking what they currently have because there are a lot of stopgaps. So I am very happy to notice or to note that they are making changes to accommodate both the surrogate and the intended parents. Now I'm bringing it home to us. I think I also appreciate Mrs. Alao Akala for sharing her experience. And while she was talking, she raised up quite a number of issues that we need to consider. The social, the cultural, the religious environment in Nigeria when we are drafting any bill. Again, we also have to look at the stigmatization that happens. Most times the surrogate may want to remain anonymous. So we also have to put a lot of things into consideration. And then the last but not the least is the fact that we need to acknowledge the society or the body we have in Nigeria or the authority we have in Nigeria that is coordinating all fertility services, but because the truth is you can't have surrogacy treatment without going through a fertility clinic, without undertaking the services of a fertility practitioner. So that except we want to do traditional surrogacy, which is where the man will sleep with a surrogate, but I don't think that's what we are looking at. I want to believe that we are looking at gestational surrogacy, which is a surrogate just carrying the pregnancy for a couple or for a single parent. So if that is what we are looking at, then we cannot be having this discussion without having to consult the fertility authority that we have in Nigeria, which is Association for Fertility and Reproductive Health. They should also come in to tell us their own
contribution, we should actually leverage on them and get a lot of input from them. Because I don't think it will be okay to pass a bill and then you now go back to them and start asking them for their input. I am just thinking that the right thing to do is to consult them, carry them along, have the bill passed with their input, so that when a surrogate is coming to their clinic, they know that they also contributed to whatever we have as a nation. And if we do all this, we will also come out with something that is workable for us as a society. And I see a lot of comments or chats going on, bans commercial surrogacy, do this. We have to look inwards. We have to look at our environment. If you say you're banning commercial surrogacy, will you be able to get surrogates? We need to look at that. We also have to look at other countries like the US and Canada, even the Asian countries. We have to look at what they are practicing, because in US, I don't think they have a national bill. What they have is according to states. So we also need to look at what works, not just sticking to a particular jurisdiction and then running with it. This is my thought, and I'm hoping that at the end of this discussion or conversation, we will come.
Please, sorry, please, can we see your video so we can see your face, please? And thank you so much for your.
Okay, let me do that. Can you see me now?
So much. Thank you so much for your intervention. We're very grateful. Okay, we'll take just one more person for the intervention. Just one more person. Then Romanus Eze, you wanted to speak. Please turn on your video and you have 30 seconds for your intervention. Thank you.
Oh, yes, thank you so much. And I pray to stand on the existing protocol. I wanted to speak because I had a live issue which I was called upon to intervene about 2 weeks ago, actually. And while I was
can you turn on your video, please?
My video is on.
We can't see your video.
Can you see me now?
No, we can't.
Oh, thank you. So I purposely want to speak because I had a live issue which I was called upon to intervene. That was about 2 weeks ago. And that while I was trying to read up materials and advise accordingly, I came across this webinar slated for today. The issue in the live issue happened to be a gestational mother who carried babies for a surrogate for a legal mother, but could not carry the babies to term while she was in one of the medical facilities for delivery. They were delivered, but could not survive. So the question turned that the fertility clinic, which were apparently the middlemen, decided not to or refused to pay her what they agreed. Apparently, they've agreed on a fee to be paid to the surrogate mother. They refused because the children were not carried to terms and couldn't survive. So, and this lady, the surrogate mother, threatened to commit suicide. So the issue boils down to the fact that where it happens that the surrogate mother could not carry the baby to terms, what happens where either the legal parents or even the intermediary, which happens to be the fertility clinic, what happened where they decide not to pay the remuneration or the reasonable expenses that have been agreed upon beforehand. So this thing should be looked at, and I would like to have comments from our panelists to guide us also and guide the parliamentarian in amending the law, streamlining the bill that's to be passed in this regard. Thank you so much.
Please, can I say something? Can I contribute to what he said?
Sorry, please, who's speaking?
My name is Mrs. Oluchi Isilebo. I had my twins through a surrogate, actually. That was December 6th, 2015. After 13 years of infertility, the journey and everything, I even went to Israel, had it in Herzliya Medical Center where it failed, and I came back. And fortunately, I had one in Nigeria here through a surrogate. That was after my doctor said, I've had the first one, the second IVF, the third IVF, the fourth IVF. And my doctor now said, Oluchi, you're not going to go come to my clinic again to have an IVF without a surrogate. So fortunately for me, in 2015, I had a family friend, a very good family friend, still my friend still today, and she decided to help me out. But she said she was a single mother. She is still a single mother. So we went through it, and to be sincere with you, you know, these things are good to. And when we're passing a bill or when we're doing something, we do it in the right way. She insisted that I would pay her, which I did. I paid for accommodation for her, placed her on monthly salary, gave her logistics for antenatal, gave her clothing and everything. And she gave me twins. Until today, we are still friends, fortunately, thank God. Now, it was after that experience that I registered my company. I have a surrogate agency company, Love and Care Surrogate Company Limited, Nigeria CAC, well registered, and I have my agreement, which I signed with intending parents. I have children today in America. I've not been able to. I had one. They were from UK, but I don't know how they took the baby over. But I'm meant to understand that taking children to UK is pretty difficult. So I even just had a baby on the 15th of this month by a surrogate mother. So what he is asking, what Mr. Romanus is asking is an unfair treatment, because I have it in my own company agreement that you sign with me. I have it there when a surrogate loses a tube, when there's an ectopic pregnancy and a surrogate loses a tube, there's something the intended parents must give. I have it when a surrogate loses a womb, which of course I've not experienced. We have what you pay, even in case of death, because we are talking about human beings here. We have to include death too. Even in case of death, we have what they will do. If a surrogate carries a baby to a certain extent and the baby 5 months, 6 months, even 3 months, an intended parents should be able to compensate, should be able to say, take this and thank you very much. I don't know if you people know how invasive and how.
Thank you so much, Madam Oluchi. We are want of time. We're really grateful for that insight. So for any agreement, you must state it clearly to the level you're carrying baby to each stage. Must be stated, if something happens to the children during birth, will you be compensated or not? So it must be stated in the agreement for it to be enforceable. We're very grateful. Thank you so much, ma'am. I think Tara Smith made a comment, but I can't see it on the chat. So that's the last intervention for today because we are out of time. We need to close. So Tara Smith, please, if you're there, can you state what you wrote down in respect of the surrogate and insemination? Hello, Tara Smith, are you there? Okay, so in the absence of that, I would
is in the chat box. You can check it. Our comment is in the chat box.
I'm trying to check it. Okay, our last comment. She said, Tara Smith, can I just say that in the UK, surrogacy requires the artificial insemination of the embryo into the surrogate. No sexual intercourse. That's in the UK. There's no traditional surrogacy is where the surrogate egg is used to create the embryo, and gestation is where the embryo is made up of the intended parent's sperm and egg. So no biological connection to the surrogate. Thank you for inviting us and good luck. So that's what Tara Smith has to say. There must be an investigation of the surrogate. So there is no sexual intercourse between intended parents or the surrogate. Okay, thank you all so much for your wonderful interventions and your questions. So may I please hand over to our chairperson of the committee for a closing remark. Madam Nancy, please.
Thank you very much, Chris. So it's a vote of thanks that I'm going to give. It's truly been an engaging and insightful webinar, just like we wanted it to be. I know we wanted to have more time, but unfortunately, there's nothing we can do about increasing the time. I want to thank everyone for making out the time to be here today. And I would especially thank the panelists, starting with the honorable member. Thank you so very much to you, and now to your wife as well, for making out the time to be here today and for helping to lead the conversation with sponsoring the bill and seeing to it that it has passed the second reading in the House of Representatives. So thank you very much for coming today and delivering this very passionate keynote address. It's a personal story that you have shared with us, and this has moved you to do what you have done, and it is very much appreciated. I thank also Colin Rogerson. Thank you so much for your time with us today, sharing your expertise. Just one phone call and you were on board with us. Thank you very much. Thank you, Tara Smith. A lot of sacrifices made to be here today. I don't need to say much, but you know what I'm talking about. Thank you for that, and for staying on even till now. The webinar was meant to last for just about 2 hours, and we've overshot that, and we're still here answering questions, you know, engaging with us. Thank you so very much. We also thank Nba-Slp for this paper, and unfortunately he's not here to personally deliver it and interact with us, but he has delegated that task to someone who has also done a good job. So we say thank you.
Thank you, Ma.
I thank especially also our chairman of the section, Nba-Slp SAN. Thank you so very much for all your support. And the vice chair who stepped in today to deliver the welcome address. Thank you so very much for doing that. I thank the secretariats of the section on legal practice. You've done an amazing job. I know we've had the technical challenges this morning, but we've overcome it. And thank you so very much for working so hard. I thank the officers of the Family Law and Human Rights Committee for your work all through behind the scene. You've been doing a great job. Thank you so very much. You're very supportive to me as well. I thank the committee as a whole. We've done it. We've done it today. This is something we've looked forward to from the beginning of the year, without knowing that there was something cooking in the National Assembly. We thought of the surrogacy bill. We thought of how we put things together. And then suddenly one day in the news, we saw that the bill already passed the second reading, and we just keyed into it. And here we are today, starting this conversation. It's just the beginning, because I know there is so much more to be done. And the consultation would go on, and particularly on the day that the public hearing is fixed, we will be there, and we'll welcome as many people that would want to also join in that forum to be there, so that we can have a very robust bill come into law and guide our practice in this area. I thank everyone, particularly everyone who stayed on from the beginning up to this time. It just shows your interest in this area of the law. We're really very grateful that you stayed on with us. Thank you, thank you, thank you so very much. We appreciate you. So with that said, I think we've come to the end of the webinar. I want to believe that our objectives were achieved. We've had a very interactive session. We've been able to look at our own bill and do some analysis and compare with existing legislations in other jurisdictions like the UK. This is not the end of it. This is just the beginning, if I would say so, because there are other jurisdictions engaged in this practice. I would want to learn from them as well, so that we can have a better legal framework to guide what we do in Nigeria. So thank you very much. Thank you. There's no better way to say thank you than to say thank you. Thank you for today. God bless you all. I thank God for everything. All right then.
Thank
So
you,
that brings us
everyone.
to- Thank you. Thank you so very much. God bless you. Thank you. Thank you. We still have over 100 people still signed on. Well, we've come to the end. So thank you so very much, everyone. Thank you. Thank you. Thank you. Father Kemi, are you there? Thank you so much. Thank you so much.
Hi, Nancy. Longest time.
Hello.
So good to
Good
see
to
you. How
have you
now?
here. I hope you had a great time.
I did. Very good. Very, very good. I hear it's snowing. I hope the snow is not making you too cold. How's the family?
Everybody's fine.
Oganka. All right. Take care. I've already dropped a chat for you on your WhatsApp.
All right.
All
Thank
right.
you.
God bless you. Bye.
Bye. Father Kemi.